Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. I'm a legal certified specialist in California workers' compensation, and I'm a trial attorney. I wanted to briefly go over some recent case law that has come down that's actually very advantageous to injured workers across California. Before I go into the facts of this case, I want to briefly lay down what the injured worker's entitlement is when they're injured in regards to a supplemental job displacement voucher. Ultimately, the law is as follows. If an injured worker sustains an industrial injury that results in permanent disability, ultimately the legal finding of permanent disability is what triggers the entitlement to this voucher. The voucher is not a check to the injured worker, but it's a check to a school to be retrained. Previously, between 2005 and 2013, that check to that school would be between $4,000 and $10,000. After 2013 and something called Senate Bill 863, that changed to being $6,000. Now, once again, what triggers the injured worker's entitlement to that voucher is a finding that they have sustained quote-unquote permanent disability. Now, what's supposed to happen is once a doctor has found the injured worker permanent and stationary and has opined that there's permanent disability, what should happen is that physician should fill out a separate document or form that potentially entitles them to that voucher. What that doctor should do, that doctor should address and look to see what the injured worker's job description was and whether there's work restrictions that enable that person to work within their general job description, or whether the employer can potentially accommodate those work restrictions. What then happens is this physician's findings and potential discussion of work restrictions should be sent to the employer, or rather the claims administrator, who then sends it to the employer. Then what happens is the employer has 60 days to really see if they can make a reasonable accommodation. And if the employer does say, hey, listen, we can take you back and we can accommodate those work restrictions, then in essence, the injured worker is not entitled to that voucher. If the employer doesn't do that, then theoretically the injured worker is entitled to that voucher. Now, the employer must say, yes, I can accommodate those work restrictions, and yes, I guarantee your job for a year. If that is not done, and there's specific steps that need to be done or followed, if that's not followed, the injured worker is entitled to this voucher. Now, the case that I want to discuss is something called Fndkyan versus Opus One Labs. Fndkyan is Fndkyan, and what this case is adjudicated is who has the burden of proof here, right? Now, ultimately, I have always contended that it's the defendant's burden of proof to show that my client is not entitled to it. That is that once I have established that my client is injured and has sustained permanent disability, that triggers the fact that they're legally entitled to the voucher. Then the burden shifts to defendant to show that they complied with the rules and regs and the labor code to show that they're not entitled to that. That is, they have to show that the employer made an offer to accommodate that work, that they have done that within 60 days of the physician's finding that they had work restrictions, and that they guaranteed that job for a year. It is the defendant's burden to prove that. That's what I've argued from day one, and that's what this case has finally come down and confirmed. So, Fndkyan versus Opus One Labs is a very good case, and essentially what it holds is it's the defendant's burden to show that the employer and the claims administrator have complied with the law that shows they're not entitled to the voucher. So once an injured worker shows that there's permanent disability, that triggers the fact that they're entitled to the voucher, and it's the defendant's burden to then show they're not entitled to the voucher, which is a very, very big deal. Now also, why is this so important? It's important because one, it's a $6,000 voucher to the injured worker that can be used to help them retrain and get back in the workforce in a different capacity. But also, the injured worker may be entitled to a separate benefit of an additional $5,000 based on what's called the Return to Work Fund. And what triggers that potential entitlement to the additional $5,000 is the entitlement to the voucher. So There's about $11,000 on the line here, so it's very important to adjudicate whether an injured worker is entitled to the voucher and make sure that it's upheld so that they can get about $11,000 in vocational training to try to get back in the workforce. Once again, I'm Michael Burgis. If you have any questions or concerns about a work-related injury or entitlement for a voucher or the return to work fund, feel free to give us a call. We're standing by.